Township of Oshtemo versus MEDTC.
Good morning, Your Honors.
Time to lay out your case, presumably the outcome determine the issues that we believe we should determine. And I encourage you, therefore, not to use a lot of time and throw clearing, but go directly to the issues you have court. Please understand. You may proceed.
Yes, Your Honor. Thank you. I'm James Porter, attorney for Appellant Oshtemo Charter Township. With me today is Rob Thal. He's the attorney for Michigan Townships Association and the Michigan Municipal League. Contrary to Appley's contention, what is at stake today is not the integrity of the electrical grid. It is the integrity of the Michigan Constitution and the rule of law. We are here pursuant to this court's order standing for the proposition that the Electric Transmission Line Certification Act, Public Act 30, is inconsistent with the first sentence of Article 7, Section 29 of the Michigan Constitution, and is therefore unconstitutional. The township's right to grant or withhold consent to a public utility under that first section of Article 7, Section 29 was given to the township by the people of the state of Michigan, and the legislature cannot dispense with that right. The consent requirement of the first sentence of Article 7, Section 29 is specific and it's distinct from the reasonable control provisions in the second sentence of that same section. And the specific right to consent cannot be subordinated to the general provisions of the Constitution or state law. Oshtemo's public utility ordinance was an exercise of that right to consent or to not consent to a public utility. It's important to note in this case that MEDTC never sought or received consent from the township to be in the township. We believe that stare decisis should not be used to uphold the constitutionality of the Electric Transmission Line Certification Act. In fact, we would argue that many of this court's preceding cases would stand squarely for the proposition that consent is absolutely required, and therefore the ETLCA is unconstitutional. Act 30 is unconstitutional because the Michigan Constitution was ratified by the people, and the people granted the township the right to consent or not consent to a public utility's use of its streets or public places. The Michigan Constitution, unlike the federal Constitution, is not a grant of power to our legislature. It's a limitation on its general legislative authority. Because of that fact, the Michigan legislature cannot take away the township's authority granted to it by the people. Also, the legislature cannot adopt legislation which conflicts with the Constitution. Under the plain reading of Section 3 and Section 10 of Act 30, the MPSC's grant of a certificate of public convenience and necessity preempts the township's ordinance, and therefore it is unconstitutional. The MPSC in this case specifically held that pursuant to Act 30, the certificate of public convenience and necessity that it granted preempted the township's ordinance. The Court of Appeals held that the certificate took precedence over the township's ordinance. Well, we would argue that regardless of whether you call it preemption or taking precedence, the effect is the same. No consent was requested, no consent was received by MEDTC. The consent requirement of the first section of Article 7, Section 29 is separate and distinct from the reasonable control provision in the second sentence of that same portion of the Constitution. As this court is well aware, there are three basic rights: the basic right to consent to a public utility, the right to grant a franchise to a public utility, and the right of reasonable control over a township's streets and public places. As Justice Markman so keenly pointed out in the City of Lansing versus State of Michigan and Wolverine Power, 480 MISH 1104 in 08, the right to consent and the right of reasonable control are separate and distinct rights. And the failure to distinguish those two provisions arguably gives no effect to the first sentence of Article 7, Section 29 whatsoever. We believe that this is a self-effectuating right, contrary to what appellees would argue, because it requires no further interpretation, and we cited cases for that position, Consumers Power versus Attorney General. The Court of Appeals in this case actually took Article 7, Section 29, and they subordinated it to Article 7, Section 22. But you can't do that, because when you do that, you elevate the general over the specific. Yes, Your Honor.
Justice McCormick has a question, a threshold question that every member of the court would like you and the other advocates to answer.
Yes, Your Honor.
So help me with this. Why is METC a public utility at all under Article 7, Section 29 when it's only involved in the transmission of electricity? As far as I can tell, the historical understanding of the term utility and the historical definition of that was aimed at the monopolist energy giants that used to do it all. They did power generation, power transmission, power distribution. That's all changed, and the legislature has saw fit to change the way we think about electric utilities. Specifically, they've amended Act 30 to include METC and shops like it as among those who they can grant waivers to. But they had to change the list of groups they could grant those waivers to, adding affiliated transmission companies. If METC is an affiliated transmission company and not a public utility, as Article 7, Section 29 is aimed at, why are we here?
I believe we are here because it is a public utility. I don't believe that the legislature has the right to separate and take the common understanding of what a public utility is and redefine it so as to exempt them from the state constitution. They are part of the entire process. If in fact the transmission company didn't exist, what would the other public utilities do? They would have nothing to sell or provide to the community.
Are you suggesting that METC is a regulated utility?
I'm not suggesting they're necessarily a regulated utility. What I'm suggesting is they're a public utility as defined by our Constitution.
Okay, I'm sorry. I misspoke. Are you suggesting that they're a public utility?
Yes.
And if so, why? Where do you look for that definition?
I look for it in the common understanding of what the people understood when they adopted the Constitution.
That's confusing. We usually try and look for like law for definitions, not just common understanding.
Well, I understand that, but you can't separate them from the entire process. Simply because Consumers Power separated their transmission from their distribution lines doesn't change the effect that they're part of the entire process. That entire system is an integrated system, and you can't separate one portion of it from the other and still have a public utility.
Well, the legislature seems to think you can, because they decided when they amended Act 30 that they better add these other categories of entities that waivers could be granted to, including affiliated transmission companies and independent transmission companies. I don't know, because it's not in any of the briefing, what you would call METC as between those two, but probably one or the other. And the legislature in the amendment to Act 30 said, and the Public Service Commission can regulate those as well as public utilities. If that's the way the legislature is describing this entity, why should we read public utility in this section of the Constitution to include it?
I think one of the reasons that you should is because, again, going back to the Constitution, when you look at the rights that were granted to counties, townships, cities, and villages, as this court pointed out in its recent decision involving associated builders and contractors, you've got to look at that section of the law in light of Article 7, Section 34, which says that the Constitution and the law should be broadly interpreted to liberally give effect to the powers and the authority of the local units.
And if this case was, if you brought a case against consumers because you didn't like the distribution lines they were putting up throughout the township, maybe we'd have to get to all of the questions that have been briefed in this case. But I'm wondering whether we've just kind of missed the step one question, the first principles question.
Again, I don't believe we have, because the whole concept of the analysis is based upon the Constitution. What was the common understanding of people's authority that they were granting to the townships when that was adopted? And a public utility would be any utility distributing electricity throughout.
That's right, distributing. There's a difference between a utility that distributes electricity. That's what they do now, right? That's what Consumers does. That's what DTE does. They generate power and they distribute power.
But
They have sold off the transmission piece to other companies, private companies. METC is a subsidiary of ITC, correct?
I understand that. Yes, they are.
Okay.
But-
And for some reason, the legislature knew that it had to amend Act 30 to make sure that the Public Service Commission could still grant waivers to these other categories of actors that are now involved in the modern energy market, right? The modern energy market is really different than it was in 1929 or 1963 even, and the deregulation of it and the ways in which power is now sold nationally. You know, an electron gets on the line and it doesn't know if it came from California or Detroit. So the energy market has changed. The legislature responded to it. And I don't understand why we therefore have to read in affiliated transmission company, which is clearly separated in the way the legislature thinks about it, to public utility in this section of the Constitution.
Again, I would take you back to the section that granted the authority to townships for control over its public rights-of-way. And at that time, when they described public utilities were transmission, distribution, included all that portion of the electrical grid.
I think I understand your argument. Let me ask a different kind of question then, assuming that you are correct on that an independent transmission company is still a utility for the purposes of the Constitution, even if it's not within the contemplation of this legislature. You make a very odd argument that caused me to have whipsaw. You argue that Article 7, Section 29 has three constituent sentences that create corollary independent rights. The first is a right of refusal for public utilities wishing to run lines through a municipality, and you point to the third as providing only a reasonable right to regulated municipalities, streets, etc. And you insist that the first sentence gives you the right to say yes or no, but then you say, subject to your client being arbitrary or unreasonable. I don't understand how you make the argument and why those aren't inconsistent positions.
I don't believe they're inconsistent, Your Honor. I think it's a good question. But the reason
That's why I asked it.
Obviously. First of all, the initial issue of consent would require that it not be withheld arbitrarily or unreasonably.
And that's where, okay,
And that,
where did it stop?
right.
You got it in front of you, the Article 7, Section 29, the first sentence?
Yes.
What does it say? You want me to, look, I'll read it for you, I got it. No person, partnership, association, or corporation, public or private, operating a public utility, something that Justice McCormick was discussing with you, shall have the right to the use of the streets, highways, streets, alleys, or other public places, et cetera, without the consent of the duly constituted authority of the township, city, or village. Now, where's the reasonable, arbitrary? Where do I look to get reasonable and arbitrary as a precondition for the exercise of the consent of the municipality?
It's provided by the interpretation and case law of this court and subsequent courts, including probably most recently in the City of South Haven versus South Haven Charter Township case.
Okay, so you're acquiescing in the importation of an arbitrary and reasonableness standard to the exercise of consent in the first clause of Section 29.
Yes, Your Honor, and I think it is different, though, from the reasonableness clause in the second sentence. The first clause would require a court to make a determination whether we are withholding consent arbitrarily or unreasonably.
Wait, 1 minute. Well, why would it necessarily be a court? Why, if reasonableness and arbitrariness is a jump ball, why can the legislature determine who in the first instance makes that call?
Looking at the City of Taylor versus Detroit Edison, this court in that case basically said the constitutional validity of the township's rights under Article 7, Section 29, the first sentence, is not within the purview of the MPSC. So I think the distinguishing factor here is once you get into the reasonableness provision in the second sentence, then yes, rules and regulations that have been adopted and implemented by the MPSC would come into control. But the difference is whether or not you've initially had consent or whether or not you're arguing over a reasonable provision provided for in state law or in state regulation. Once you're in the community, then the reasonableness standard applies. Getting into the community requires consent. And so I believe they are separate and distinct. And I think that was discussed by the court in the case of City of Taylor versus Detroit Edison, because the court said the MPSC has no jurisdiction to consider the scope of the city's constitutional authority under Article 7, Section 29. But once you adopt regulations and rules, then under the reasonableness provision, are your lines above ground or underground? Well, in that case, they were already there. Our case is different. This is a consent case. It's not a reasonable control case.
Okay.
Counsel. Yes, sir.
When you respond to a public utility and indicate that they will be able to use your highways, albeit with certain conditions, are you consenting or are you not consenting? Does that have any implications for whether or not we then move from the first sentence to analyze what the applicable standards are, or the third sentence?
I believe it does. If initially we consent with whatever conditions are applied.
So you're saying that is a consent as opposed to a non-consent when you indicate you can only build here if you abide by the conditions that we set forth?
Yes, Your Honor. If I could, going back to Justice McCormick's question, as Chief Justice so aptly pointed out, the state constitution says no person, partnership, association, corporation, public or private, operating a public utility. Again, that is very broad language, and I would argue that we shouldn't restrict that language regardless of what the Michigan legislature has done.
I'm not sure I understood your answer to Justice Markman.
In the first...
Just a moment.
Sorry.
I understood you to say that the ordinance here is actually consent with conditions, and therefore subject to the third clause analysis, not the first clause. Is that correct?
If we were in the process of moving lines within the township or relocating lines in the township and METSI already existed within our community...
No, I'm putting to you my question. Does an ordinance which says you may build provided you follow these conditions, is that a consent or not?
It is if it's the first time that they've entered the community.
Right, okay. So we're under the third, in this very case, our analysis should be guided by the third clause, not the first clause. Isn't that correct?
I would argue no, because they have not been in our community. METSI's never sought or received consent of any kind from the township.
Well, I guess you misunderstood my initial question. Okay, fine.
Counsel, I'll ask a question. And I always like to kind of ask things in a more pragmatic way. I want to give you kind of a hypothetical. Let's say you have a hypothetical situation where you have, I just like to use my town for an example, Birmingham. Let's say you have a situation where Pontiac or Auburn Hills needs a power line to run through Birmingham in order to get necessary power for its residents. And Birmingham decides that it's not going to grant consent to such construction. Is your argument that that should be allowed? And how do you look at this, the overall ramifications that this would have as it pertains to kind of neighboring communities and the impact that this decision could ultimately have in terms of construction of necessary power that has to go through one city to benefit that of another?
I think that would be exactly analogous to the City of South Haven versus South Haven Township case. They needed water. They needed to go through the township. And the court said, you still have to get consent. And even though you can't arbitrarily or unreasonably withhold that consent, that puts the issue in front of a court for a full due process hearing on that issue.
Due process? Why is the determination of reasonableness due process implicated?
Again, I believe it would take a court to make a determination.
I buy, what's for the purpose of this question, I buy the argument that the first clause, reasonableness, arbitrary analysis, is a judicial determination rather than an administrative determination. What standards apply then? What as a judge do I determine, how do I determine whether your client's failure to consent is reasonable or arbitrary?
All I could say is it would require the court to look at the past decisions, Detroit versus Detroit Railway, People X Mayberry versus Mutual Gas and Light Company.
Just more, indulge me. Tell me what criteria I use. Extract from those cases for me. So you tell me directly. If I'm the arbiter of whether the decision of your client is to decline here, this transmission line, is arbitrary or reasonable, what standards do I apply?
In all honesty, Your Honor, I don't know that the courts have necessarily fully fleshed that out.
So I get to do it based on my internal feelings, the vibe of the thing?
Well, I believe that the Court of Appeals in the City of South Haven case, they looked at 4 different criteria that the township wished to impose, and they felt that those were not arbitrary or unreasonable. So
now I get to determine the basis of reasonableness or arbitrariness on the conditions your client imposed on consent, that these lines be buried near when they're proximate to roadways, etc.
Correct, Your Honor.
You would agree with the Chief Justice, would you not, that you have arguably made a fairly substantial concession in acknowledging that the first sentence contains the same standard set forth in the third sentence, even though the third sentence sets that forward explicitly and the first sentence has no such language at all? In other words, the plenary nature of your consent, it seems to me, has been acknowledged by you to be limited by the same language in the first sentence as now exists in black and white only in the third sentence.
I wouldn't say that, Justice Markman. I don't believe it's exactly the same. Again, the reasonableness standard under the third or second sentence, the third criteria, I think focuses more on an issue of whether or not regulations where you have an operating utility are consistent or inconsistent with state law, makes the determination whether there's reasonableness. The first criteria, I think, is a higher standard. Because it requires the court to determine whether or not it's arbitrary or unreasonable.
But of course, I again reiterate what the Chief Justice said. The court decides. We understand that that's the institution that has that authority, but nonetheless, it has to have some standards, does it not? What are the standards?
Again, I have to confess, in looking at all of the cases dealing with this issue, because what the court typically did was require consent, similar to what this court did in Wolverine, or the mayor of the city of Lansing versus Lansing and Wolverine Power. This court said you need consent.
I thought you just said, in making the reasonableness arbitrary determination, the court can look at the conditions your client's ordinance would impose on the transmission company to obtain a consent. Isn't that right?
That's correct.
So I can determine that bearing is too great a burden and therefore unreasonable.
I believe a court would have that authority. The difference here
So
is...
your client is much more comfortable climbing into my gut than what? What's the alternative?
The alternative is an MPSC that has no standards over what they're going to decide. They simply, as a matter of...
I don't have very many standards that you've articulated, but you're happy with that outcome.
Well, with all due respect, Your Honor, I have more confidence and faith in the judicial system than I do in an administrative agency.
Well, I'm happy for that. But you shouldn't be.
Is there any significance to the fact that the third sentence continues to be distinctive from the first sentence by virtue of the prefatory language that exists in the third sentence? Is there any consequence to that at all, or is it of no consequence, just as the absence of the reasonable control language in the first sentence is apparently of at least little consequence?
I think it's very important. I think that the initial sentence specifically focused upon any corporation running any kind of utility, couldn't come into the township basically carte blanche and do what it wanted. As MTA counsel pointed out, this provision of the Constitution was put in place to stop statewide grants and statewide franchises where the people had no input on what was happening in their community. Now, once you get to the issue of the roads and public places, then again, that narrows it down. This is much broader. This isn't saying you're going to come in and use our roads or you're going to come in and use our public places. This is you're coming into our community and putting a public utility through our community. Much more significant than simply using the roads and public places of a township or city.
Do you wish to reserve any time?
No, Your Honor.
Do you have anything else to say then?
Yes, Your Honor. We think that Appley's argument that the certificate of public convenience and necessity is where the conflict is at actually proves our point. If the only conflict which exists in this case is with the certificate of public convenience and necessity alone, then the rule of law has been dispensed with, the Constitution has been dispensed with, and the rule of man has been put in its place. The reason that we talked to this court about the People versus McGraw and this court's reaffirmation of that standard in the City of Taylor versus Detroit case is because we recognize that we can't act arbitrarily or unreasonably. We do think that one of the keys to looking in that direction or determining whether you're arbitrary or unreasonable is whether or not you're consistent or inconsistent with state law. Does the McGraw test apply? That's why we argued there are no state laws that would apply in this case regulating these types of transmission lines. That's why we're arguing our ordinance is not inconsistent with state law, and we think it's important because of the City of Taylor versus Detroit Edison case.
Can I ask you another question?
Yes, sir.
Is the question of whether the ordinance here is reasonable or arbitrary a legal question, a factual question, or a mix of both?
I believe it is a legal question.
So this court can decide today, in this case, whether your client's ordinance is reasonable and arbitrary.
Unfortunately, that has never been raised because no one's ever asked for consent.
I have just done so. You claim, I thought at one point you said the ordinance was in fact a consent with conditions. You backed away from that position, correct?
Correct.
All right, so the ordinance then is a no. It's a declination of consent in this context. Is that correct?
When you say it's a no, I don't understand. No to the public utility?
No to this transmission line, this proposed transmission line. As proposed, not as modified by your client's ordinance.
I do not believe that it's a no.
You don't believe it's a no? What is it?
I believe they could receive and would have received consent.
If they did the other things.
So it's a no for now.
The proposal is not to bury the line, correct? In the manner consistent with your client's ordinance.
Correct.
So under this current circumstance, the ordinance is interposed to prevent the line as proposed to your client.
I would argue it wasn't to prevent the line, but basically to ameliorate the...
It is a stopper, right? It
Because-
cannot go forward. Your client will not consent unless the conditions of the ordinance are met, correct?
I would assume that, but since we've never been asked, to be honest, I can't tell you whether the township would consent or not consent. No one's ever asked us for consent.
Can I ask, I know we're out of time, but let me ask you one more question that's just it's such a funny, as a matter of first principles, this township asserting this constitutional right as against its creator, the state creates the township, it's a little bit incongruous. So, and this isn't necessarily this won't necessarily help us solve the legal questions here today, but just like the state created the townships, the state can uncreate the township, can't it? If this afternoon the legislature was concerned about this argument, they go into session and say, we're killing Oshtemo Township. We don't like this township anymore. It no longer exists. It's not like a zombie, right? The legislature can kill it?
I would argue no.
No?
Because the cities, villages, and townships of the state were not created by the people in the legislature. They were created by the people. The Constitution, when it was ratified for the people, by the people. That's what we're arguing today.
So the state that created the township, chartered it, does not have the authority to uncreate it. Can the township wage war against the state? What's going on?
Well, again, I don't think we would wage war against the state. What
No,
I'm saying is...
I'm trying to understand, if we're understanding the constitutional relationships, I just want to know if this background, the background understanding of the relationship should do any work in thinking about how it should play out in this article that we're trying to think about. And if I'm right that the state that created the township could also uncreate it, then that might tell us something about what role or how much the township gets to have a say in when the state, its creator, says we think this is an appropriate.
Again, I would argue that the legislature is not the creator. I would argue that our Constitution and the people, when they ratified the Constitution, are the creators of our form of government, including all of the municipalities, including townships.
Thank you.
Got it.
Thank you, Your Honor.
Just like the U.S. Constitution, it's not typically thought of being created by the states, but by we the people. I suppose that's what he said.
Yeah, I think so.
You may proceed.
Good morning. May it please the Court, Assistant Attorney General Lauren Donofrio, appearing on behalf of the Michigan Public Service Commission. With me at council table are Michigan Solicitor General Aaron Lindstrom and counsel from METC Gary Gordon and Courtney Kissel. Mr. Gordon and I will be splitting our time equally.
And you're responsible for managing your time between you.
Just set the timer.
You can try.
I will try. In answer to, well, let me start with, this case is about keeping the lights on. Extended power outages endanger the lives of our most vulnerable citizens. Maintaining electric reliability is thus a matter of statewide concern. The court should find that matters of local concern must cede to matters of statewide concern. A municipality's concern for aesthetics cannot override the state's need to protect its citizens. This court should rule that the Electric Transmission Line Certification Act is constitutional because it does not impermissibly interfere with the municipality's right to grant or withhold consent, but merely limits the scope of the conditions a municipality may place on its consent. Article 7, Section 17, and Article 7, Section 29 of the 1963 Constitution must be read together. That is, the Constitution's grant of powers, on only those powers provided by law to townships, is the lens through which we must view the rights reserved to townships and other municipalities under Section 29. Otherwise, local concerns could govern statewide concerns. As this court explained in the City of Taylor decision, a municipality may not regulate in a manner inconsistent with state law. Consent is like an on-off switch. It's either a yes or it's a no. But the imposition of conditions on that consent is an exercise of reasonable control. A municipality may not be allowed to use its right to grant or withhold consent to force compliance with regulations that are inconsistent with state law. This would render the second sentence of Section 29 surplusage or nugatory. Thus, in exercising its consent rights under Section 29, the township may only utilize those powers it has been granted by law as set forth in Section 17. Simply put, the law has not granted the township the authority to regulate in a manner that is inconsistent with state law, which here is the certificate granted by the Michigan Public Service Commission. In answer to Justice McCormick's question, the Michigan Public Service Commission in Rule 460.3102 defines a utility as an electric company, whether private, corporate, or cooperative, that operates under the jurisdiction of the Commission. METC does not operate under the jurisdiction of the Commission. It operates under the jurisdiction generally of the Federal Energy Regulatory Commission. The Michigan Commission does have authority to determine the siting of lines and grant certificates of necessity, but it does not have general power to regulate the operations of METC. If I have any time left in my free fire zone, I waive it at this time.
Counsel, you say that local policies must cede to state policies, and that's really the theme, the underlying theme of Article 7, Section 29. I guess in response, I just ask you, doesn't it seem like a fairly odd way by which the legislature, or by which the drafters of the Constitution sought to communicate that idea by the first sentence of Section 29? In particular, why would they have intended to incorporate the limitations of Article 7, Section 17, when in that very sentence there was no similar prefatory language to that in the third sentence, where they said, except as otherwise provided by some other part of the Constitution? It just seems to me you've got a theory of what this all means, and it's a good theory, and it may be a theory that makes good sense in terms of responding to the concerns raised by my colleague, Justice Bernstein. It's just not clear that that's incorporated in this particular body of law.
There are three answers to that question. One of which is that it's possible that the drafters intended that the second sentence of Section 29 would operate to constrain the first sentence.
Well, I really would be interested in kind of some reference to the text that causes me to believe that these are connected. I mean, please answer your three questions. But so far, all I've heard were policy justifications that seem to run counter to the express language in the first clause of the first sentence.
Of course. These two provisions are to be read in harmony, if they can be.
Which two provisions?
17 and 29.
Let me suggest to you, I see nothing incompatible or in conflict between Section 17 and Section 29.
I agree with you.
Okay, well, I don't see the general, which is 17, trumping the specific, 29. So maybe we see a different harmony. You apparently think we can import 17 into 29. I see no invitation to do so in the language of Section 29. It seems to be an independent, standalone rifle shot authorization for a municipality to say no to any public utility seeking to function in that community. I want you to explain to me, therefore, from a textual standpoint, using customary ways that we associate constitutional provisions, why I can either import 17 into the first sentence of 29, or why I can import the second sentence in 29 to the first clause of the first sentence.
Because you cannot read individual clauses of the Constitution in isolation.
But unless they are intended to be so.
Unless they are intended to be so. However.
So let me just ask, as a matter of constitutional contemplation, is it possible that the people can give a very explicit right that is that is nowhere contradicted in any other provision, such that that's what they meant?
In this context, no. And the reason is because the municipalities are subdivisions of the state, and they can only exercise those powers that are granted to them by the state.
No. Section 29, first clause, first sentence, is an express grant, arguably, that the legislature can't contravene.
I don't agree that it's an express grant of power. It is a reservation of a right, which is different than an express grant of power. If you look, for example, at
the
section...
second sentence looks like more like a reservation. It says so explicitly. But the first clause of the first sentence has no similar reservation language. You're not making much textual sense to me right now.
Well, when the Constitution wants to grant a power, it knows how to do so. If you look at the text of Article 7, Section 22 of the Michigan Constitution, it says, each such city and village shall have power to adopt. That is an express grant of power. There is no express grant of power in Article 7, Section 29. So we have to look at it in terms of this is a right that's been reserved, but what powers have been granted? And Article 7, Section 17, unlike Article 7, Section 22, which actually expressly grants powers to cities and villages, Article 7, Section 17 is phrased very differently. It says, each organized township shall be a body corporate with powers and immunities provided by law. It does not say, as Article 7, Section 22 says, subject to the Constitution and law. It specifically says, provided by law, which means that the powers that a township has are only those powers granted by its superior state.
So if the legislature tomorrow passed a statute saying no municipality covered by 29 may withhold consent to transmission to a public utility, that would be sufficient under, what is it?
No, it would not.
Why not? You're saying that provision of the Constitution sucks the authority of the municipalities to do other than the will of the state, as mandated through legislation. Why wouldn't that work?
Because it's not that simple.
Of course it isn't, because 29 has independent significance, doesn't it?
It has significance, but it is not independent.
Okay.
The significance is there is a difference between being able to withhold consent or grant consent. This is that on-off switch I was talking about earlier, where if you have, and as the township has conceded, that consent cannot be arbitrarily withheld or unreasonably conditioned. And when we're looking at whether that consent has been unreasonably conditioned, we are at that point looking at the reasonable control provision, because the ordinance that we're talking about is not an ordinance that says yes or no. It is an ordinance that regulates the use of the streets, highways, and public places.
So you too concede that the ordinance, as this case is presently formed, is neither a consent nor a negation?
It's a condition upon consent. METC in this case has been operating, and I'm sure counsel for METC will go into more detail on that, but they have been operating within the township. So this is not the first time METC has ever operated within the
That's
township.
something of consequence, do you think?
Well, it is, in that Mr. Gordon indicated that if this were the very first time METC had set foot in the township, then it was not, then the ordinance was not a grant of consent, but that if METC had been operating within the township, then the ordinance was merely a condition upon consent and was a grant, but with conditions.
You know, I don't have a very sophisticated question here, but I just wonder what is left of Section 29, particularly the first sentence, when all's said and done in light of your theory of what this constitutional provision means. That is, when there is an absence of consent by a township, it's generally going to be in the context of the situation that Justice Bernstein just described, when the township is used as kind of a going through point for some larger project. So what is it that those circumstances will tend to have in common? They'll tend to have in common that there's a conflict between the locality and some certificate that's been issued by this statewide regulatory commission. There'll tend to be, of course, some interest on the part of the state in some larger project. There'll tend to be either a denial of consent or else conditions being imposed upon the project that will make it more burdensome. There'll be more communities that will be harmed by the failure to give consent than will be benefited by that community which itself refuses to give consent. So in almost every one of those cases, it's not going to be a very extreme conclusion that reasonable control in those circumstances has not been given by the township in controversy, in the township in question. What is going to be left of this provision if you insert that reasonable control provision along the lines of the third sentence, and you insert the prefatory language that also is absent from the first sentence? What really is the effective authority that a township has under those circumstances ever to prevail when it either denies consent or alternatively agrees, but only subject to certain conditions?
It may continue to grant or withhold consent or condition that consent upon compliance with regulations that are not inconsistent with state law. In this case, the ordinance was passed
Well,
specifically.
they're always going to be inconsistent with state law. That's the purpose of the certificate. The certificate is pursuant to state regulatory law, is it not?
Well, it is. However, as in this case, one of the things that the commission has to consider in deciding whether to grant the certificate or not is whether there are ordinances in the communities that need to be complied with. Now, in this case, there's a factual determination that was made. The METC provided a significant testimony about why this condition was unreasonable, in that it was 5 to 7 times more expensive to build underground, that maintenance would be more expensive, and so on and so forth. In response, there was no testimony whatsoever on the part of the township. The township didn't defend the reasonableness of its utility ordinance. Had it done so,
But counsel, isn't there reasonableness in that guideline that you just gave, that the people who now are subject to this construction or to this voltage going through or this project going through are going to lose tremendously in the values of their property? I mean, there's a number of different arguments that a person could make. Isn't that just kind of pro forma?
Well, This is, again, I mean,
But
we
Carla,
have
just
takings,
trying to understand,
for
but just trying to
example.
understand the township's position. Would you want to live next to, I mean, would you want to live next to this type of a project?
It wouldn't be my first choice. However, my personal interest in the aesthetics of my property cannot trump the rest of the state's need to have lights on,
No,
to
I
have
get-
heat.
And Council, I get that, and totally on a policy basis, I can completely understand where you're coming from. But if you look to the 1908 convention, you know, where this was adopted, and then no one changed it in 1963, you know, it seems like this is kind of a steadfast component of the framers, that Michigan's a home rule state, and thus, because Michigan's a home rule state, this is governed by what the framers wanted. I mean, ultimately, like, I understand your argument. I totally respect it. But the question I have here is how do we substitute our kind of judicial temperament as it pertains to kind of what the creators and the framers of the Constitution adopted both in 08 and in 63?
Yes, in 1963, in fact, this topic came up specifically during the Constitutional Convention. And Delegate Elliott explained the concern of the legislators in defeating a number of attempts to change the language of this provision, that this language has developed certain legal traditions over the years. And we felt that to develop a whole new case law on public utilities was dangerous.
But the language wasn't changed, though.
Exactly.
That's the
They were
point.
afraid that if they changed the language, then all the case law which has sprung up around this case, like the City of Niles case, Union Township, all of those cases that say that state law has to trump inconsistent local ordinances, would go by the wayside. It was specifically stated that we felt that to develop a whole new case law on public utilities was dangerous, where we might only be attempting to improve the language itself. It was important to the framers of the 1963 Constitution that they maintain that case law, that the understanding of the provision of which was Section 28 under the 1908 Constitution remained the same, and that judicial interpretation remained the same.
But they made a choice, though, a conscious decision to leave the. I understand, you know, exactly what you're talking about, but again, the framers made this determination and decision. A decision was made when they balanced it to leave the language as it was.
Right, and their understanding of that language was that it was limited
Do you wish to tag out?
I do wish to tag out because I am beyond my time, if that is all right.
I'm giving you the opportunity.
Thank you.
May it please the court, Gary Gordon appearing on behalf of the Michigan Electric Transmission Company, which I will refer to as METC.
All
I'd
right.
like to
Would you
start
care?
out.
Let me interrupt you. Would you care to answer Justice McCormick's initial question? Is your client a public utility within the meaning of Article 7, Section 29?
I was about to address that, Your Honor. In response to Justice McCormick's question, if I say yes, can I avoid all the other questions?
No. No, but if you say yes, I'm going to ask you why you didn't bother to point that out to us in the beginning.
A public utility is defined in various statutes in different ways. And while a corporation might be a public utility for some purposes, it isn't for others, for condemnation, for taxes, and so on. So it's difficult to say that, yes, METC is a public utility, or no, METC isn't a public utility. You're right, we did not brief that.
Apparently, you concede that it is for the purpose of Section 7, Article
think,
7, Section 29.
I apologize for interrupting. Under the Article 7, Section 29 is a continuation of a similar provision adopted under the 1908 Constitution. When that Constitution was adopted, utilities were vertically integrated. They were generation, transmission, and distribution. And
Can you just answer my question? Do you concede? You can tell me why, but I want to know the answer. Do do you concede that your client is a public utility for the purpose of Article 7, Section 29? This seems much more exquisitely difficult for you than I expected.
I would like to concede that METC is not a public utility for purposes of this section.
Okay.
I am hesitant to do so because METC may be a public utility for other purposes. I don't want to prejudice METC's options in other statutes.
The only thing I'm concerned about right now is whether it's a public utility under Article 7, Section 29, and then I need you to explain to me why it isn't, if you believe
Well,
that.
Article 7, Section, I will, for the purposes of this argument, Your Honor, I concede that it is not a utility for purposes of seeking consent under the question posed by Justice McCormick. We did not brief that, and because the assumption has been throughout this proceeding that once we're subject to regulation by the Michigan Public Service Commission as far as location, construction, feasibility, and reasonableness of a transmission line.
You're not
But
being
wait, why would you
regulated.
assume that? I mean, the Act specifically added transmission companies to public utilities for the people, for the different kinds of entities it could grant the permission to. So why do you think that because you could get the waiver, or whatever you want to call it, the certificate, that morphs you into something that the specific act that gives you the waiver defines you separately from? I don't want to help your client out too much, I guess. I don't know what I'm doing.
To the extent that we're subject to regulation by the Michigan Public Service Commission, by their rules and enabling statute, then it would be a utility.
So then would be the townships and municipalities that are obligated to be a part of this process to resolve disputes over where transmission lines go. The legislature has given the commission the jurisdiction to resolve line placement and all the disputes that come up with it. Is that not true?
That's correct.
Transmission lines as well as distribution lines. If this was a distribution line question and it was consumers, there would still be a process of having to go to the MPSC, and maybe they'd get it and maybe they wouldn't. I don't know. I could imagine the agency thinking differently about distribution lines than transmission lines. Correct me if I'm wrong, but it seems to me transmission lines are often not just intrastate issues, but they're interstate issues, which is why it's usually the FERC that you're going to, because Arkansas won't let the line go from Oklahoma to Florida, right?
Well, distribution lines by definition are local. Consumers by definition is regulated by the Michigan Public Service Commission for rates,
Right.
and many other purposes.
I'm with you on all that.
METC
And
is not.
Transmission lines and companies are different, right?
Transmission lines are different. Transmission lines the utility does not do local business.
Right.
Okay?
All right,
And to the
you've sort of given me an answer. You don't think for the purposes of Section 29, they're a utility. I don't quite know why, because you...
well, do I get a free fire zone?
No,
To the extent that Section 29 contemplates, I think, businesses that operate locally. METC does not operate locally. METC,
tell me why textually that makes any sense.
second phrase, the whole concept of Section 29 discusses the need for franchises for businesses that operate locally. It talks about, and because of that phrase read into the section, I believe that
That's arguably an independent clause following a semicolon. The franchise aspect, or to transact local.
That's correct, Your Honor. But I believe...
So I import the second clause into the first?
Yes, Your Honor. If we're reading the sentence together, I believe we do. But our argument doesn't key on that. Our argument keys on Justice McCormick's other question. Her other question was whether the legislature could abolish townships or not. Under Section 17 of Article 7, a township is mentioned in the Constitution, but it has no power. Every section of Section 17 states that the township may operate as provided by law, as provided by law, and
Again,
so
I
on.
asked your colleague this question. Could the legislature, under that constitutional provision, negate Section 29 by saying no municipality may withhold its consent to a transmission line? Period.
I don't believe so, Your Honor.
Why not?
The legislature may regulate the manner in which consent is granted. That phrase is without any substantive standards, it's without any procedural guidelines or anything else. The township cannot exercise any power and unless the legislature authorizes it by law. Now,
I just offered a counter where it completely withdraws the authority
I don't believe it can because of the grant of authority here, but the legislature...
in 29.
In 29.
So you think there is a grant of authority here?
I do believe, but as the Court of Appeals recognized in the city of Lansing, Section 29 is not self-executing. It requires implementation by the legislature. Now, the implementation by the legislature, I think, has a broad scope of authority, but it doesn't reach all the way to the extent that it can say that the township is totally removed from any consent process. Under Section 17, which as you stated, is not in conflict with Section 29, but without Section 17, there would be no mechanism for the township to operate or to exercise any of its authority. Every single provision of Article 7 states as provided by law. The township will exercise this authority as provided by law. Section 17 discusses basically creates the authority of the legislature to empower townships. And once they've empowered townships, as you recognized in your opinion in the City of Taylor case, that the authority of the township can't be exercised in contravention of state law. Now, you were addressing the third section of...
let me interrupt because...
I'm sorry, the second sentence.
I've got a question for you. If we accept Justice McCormick's position here or thought that the first section of Article 7, Section 29 does not apply to your client because it's not a public utility, something you defined as a concession. It's really, I think, an argument that was unstated, but we'll go beyond that. My question is, would the last sentence of Article 7, Section 29 still be an avenue of relief for the township? The last sentence makes no reference to...
Yes, I believe it would be, that the township can regulate its streets. It's subject to reasonable control.
And opposing counsel suggested there's a difference between reasonableness implied in the first section and reasonableness expressed in the last sentence. Do you agree with that, or do you think it's the same notion of reasonableness?
Well, you know, the appellate courts have indicated that each of the phrases of Article 29 have to be considered separately and independently. I think we get to the concept of reasonableness if you want to read the section together, although the courts have said it can't be read together. I think you get to that concept through through Section 17, which authorizes the legislature to enact enabling legislation. The legislature has done so in part through Act 30, and it has set up a mechanism by which reasonableness can be determined. It's a long, involved vetting process that the township participates in, landowners participate in.
You're losing me. Is it the same or is it different? Reasonableness under the first section, reasonableness in the last sentence?
I think it's the same.
So if that's the case, then even if we conclude you're not a public utility, there's really no relief for you there, is there? Because the last sentence is going to dictate how this case goes.
Well, certainly there is relief. The relief is that that has to be read in conjunction with Act 30. And Act 30 sets forth the standards by which the METC...
When I say no relief, I mean no relief in the conclusion that you're not a public utility, because the last sentence of Article 7, Section 29 is what's going to carry the day.
If that's correct, you're correct. I agree, Your Honor.
Okay.
Thank you. The case is submitted. I'm directing the parties to have, to submit supplemental briefs on whether METC is a utility within the meaning of Article 7, Section 29, and those briefs shall be submitted within 10 days. Thank you.
Thank you, Your
The case is
Honor.
submitted.
Long historic. I mean, there's only, I'll also do the whole section. I'm going to get your book picture. Hold on one second.
You want the justice briefs?
I got to get my stuff.
Okay.
I'm sorry. Oh, I'm